A landmark High Court decision striking down Victoria's electric vehicle tax has sent shockwaves through Australia, and it has state and territory leaders spooked that their tax revenue streams, and not just from EVs, could be legally challenged, putting billions of dollars at risk.
Yes, it's a matter of genuine concern that the High Court is reimagining the Constitution.
So what was the High Court case about? Drivers of internal combustion engine vehicles pay a federal tax on petrol, known as a fuel excise. It used to be directly tied to the amount of money that the federal government then spent on roads, but it now goes into general revenue. But if people start driving electric vehicles, that's fewer drivers filling up and fewer paying the excise. So what's a government to do to recoup the revenue? Victoria's solution was to introduce a distance-based charge for drivers of zero or low emission vehicles, and other states had planned similar moves in the coming years. Two electric vehicle drivers argued in the High Court that Victoria's charge was unconstitutional because states don't have the power to impose excise taxes on the consumption of goods. The majority of the court agreed with them, broadening the test for what constitutes an excise. The justices decided that if a tax is closely related to the production or consumption of a good and affects demand for the good, then it is an excise. And in their view, Victoria's EV tax ticked both those boxes. By doing this, the court overruled a 1974 decision which had established that a tax on the consumption of goods did not constitute a duty of excise. That's important because if states no longer have the power to impose these sorts of taxes, because only the Commonwealth can, then a number of other taxes already levied by states could become the subject of constitutional challenges. That could affect everything from gaming taxes to car registration to waste levies. The New South Wales Premier, Chris Minns, said that the previous state leadership had flagged the High Court's decision as a key risk to charges that generate billions of dollars. So where does this leave EV road user charging? There's the chance that it comes back, just don't call it a tax. In her judgment, Justice Jago said the Victorian charge was invalid because it was a tax rather than a licence or permit fee. This could mean that states could still raise revenue if they slapped an additional charge on EV drivers' car registration. For now, the Victorian government is considering whether to refund the EV charges it's received so far and seeking legal advice about the impact of the case on other state-level charges. As for the Commonwealth, by weighing into this case, they managed to help the plaintiffs beat every state and territory, who all defended the EV tax. But their win only highlighted how a local patchwork solution is problematic, and that road user charging is a job for the federal government. At least 3 Labor states are now pushing them to get on with it.